Hi, my name is Amar. Welcome to Conversations with Jennifer. Jennifer is an estate planning attorney, and today we're going to be talking about the key differences between a will and a trust, and if your situation, when would it be appropriate in your situation to have a will or a trust? And we'll be digging deeper into those. So, Jennifer, let's start with what is a will?
Okay. So, a will is essentially a document that a person can put together that's effective at their death and basically tells an executor, so a person who you've selected to kind of control and manage things, who's going to receive your assets, your tangible personal property, your real property, your liquid assets. A will, though, can involve a relatively complicated process known as a probate administration or an estate administration. And every state here in the US is a little bit different about what that process involves, how complicated it is. Here in California, we have a pretty complicated process, but other states, Vermont, Colorado, Pennsylvania, they all have a really straightforward probate process. But a will could be governed and involve a formal probate administration.
Yeah, and I know the amount of courts that deal with this have gone down over the years, and we have this large baby boom population that's getting older. It doesn't seem like a smooth process as it would be.
No. So here in California, we do we do not have an easy or smooth process. So here in California, do try very hard to put a plan in place that avoids a formal probate. So just having a will in place, you may trigger one. If you have a trust in place, that document, if funded properly, will avoid a formal probate administration. And so that's why a lot of my clients here in California tend to have a trust in place. There are other differences between having a trust in place or just having a will in place. A will, as I mentioned earlier, is only effective at death, whereas a trust is going to include provisions not only dealing with the death situation, but also in the event you were to become incapacitated. Another very complicated process here in California, known as a conservatorship, if someone becomes incapacitated. So you try very hard to avoid that here if you can, and a trust is going to include provisions dealing with that. And then a final main big difference between a will and a trust is a will is a matter of public record if there is a formal probate administration. So I don't know if any of you are fans of TMZ or looking up famous people's wills online. You can do that. You can actually find Walt Disney's will online. You can find all sorts of celebrities, and you can see who's going to receive their assets at their death. Whereas a trust is a private document. So even someone who needs to confirm certain facts about your trust, they will get either a certification or a redacted version because all of your private distribution or all your distribution provisions remain private. And can remain confidential to any third parties who are trying to get information about your trust.
Yeah, I think that's a big point. And I know there are a lot of celebrities where they haven't had the right documents and everything has become
Correct.
public.
Correct.
So I
Michael
guess just
Jackson,
to,
another great example.
yeah, yeah. Just to clarify for viewers, so let's say you pass away and you have a trust. What happens at that point?
Okay, so it depends on the type of assets you have, but if everything is inside or in the name of the trust, then at death, essentially whomever you've listed as your successor trustee in the trust will step in, will accept as trustee, and essentially almost immediately start being able to manage your assets. They do need to still wait for a death certificate because anytime you're dealing with a third party, that third party is going to want to confirm that you have in fact passed away. But they can start marshaling your assets. They can start paying your debts, your expenses, get everything in order for your taxes, and then make a plan to distribute the assets based on the terms of the trust. So that trust instrument is going to control who's in charge of all of this and who's receiving all of your assets.
Yeah, that's good, and it makes it clear that why I would say 99% of people that have wealth would need a trust, right? But I'm
Correct.
assuming there's some people out there that would probably be better with just a will, or TOD or POD. Have you ever come across a situation where it's just like, the trust would just make matters more complicated?
Yeah. So I have run into situations in the past where I did end up saying to the potential client, you may be okay with just having a will. I'd say that's rare, but there are those scenarios, and it's very much dependent, as I mentioned earlier, on the type of assets you have. So Amar, you mentioned a TOD or POD account. So those are basically bank accounts that you have a beneficiary designation associated with them. Those avoid probate. You have retirement assets. Those will go based on a beneficiary designation. 401k, an IRA, life insurance. Those will go based on a beneficiary designation. So as long as your beneficiary designation is completed and the beneficiary is alive, that's another issue, then that will avoid probate. So I met with one client. He had a lot of retirement assets. He was single, he had no children, and he wanted charity to receive his all of his remaining assets, including that retirement account. And the retirement account was a bulk of his estate. He didn't own real property, so he had a few financial accounts, just straight financial, and then a retirement account. That was the gentleman that I said, okay, you probably just need a will in that scenario. Everything will go under the retirement account based on the beneficiary designation. The small bank accounts, charity will just have to deal with that, or whomever you list as executor. But if it's a low enough balance here in California, then you can avoid a formal probate administration. That current value is $166,250. So if you have a few bank accounts, the total is $150,000. You have retirement. That's all going based on a beneficiary designation. You could just have a will, don't need a trust, and you can pass your assets pretty easily.
Safe to say that most people's financial situation would be a little bit more complex than that.
Correct. Any real property, any beneficiaries who have issues you have concerns about, even issues being they're minors or maybe not financially savvy enough at this age, at their current age, even if they're adults, to manage the assets. A trust structure is something where you can really build upon when and how a beneficiary is receiving assets.
Awesome. So I think that's a good place to wrap it up. Thank you for watching. If you have any questions or concerns, please put them in the comments below. And please like and subscribe so other people can find us as well. Thank you.
Great.